Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense lawyer. In this video, I wanted to talk about an often confused, maybe oversimplified subject of Virginia assault and battery law, and specifically, how do we evaluate an assault and battery charge when somebody calls us and says, hey, look, I'm facing an assault and battery here in Virginia, here in Fairfax or Alexandria, and we primarily operate in Northern Virginia. But frankly, if you're in charge anywhere in Virginia, I figured we'd put together this video to kind of give you a good a sense of how we look at these cases, because oftentimes folks that call us, they have no criminal record, and they're facing a charge of an assault and battery, which when you hear it, it sounds very serious. It can have very serious implications, but it may involve interaction that's almost kind of ridiculous. Interaction between the two individuals where there was no injuries, no claimed injuries, no long-term offense, no long-term consequences, maybe a push or a shove or an alleged push or a shove, things like that. And so you're probably, if you're watching this video because you're facing a charge, you're probably terrified because you're worried about the consequences, but you're thinking, well, how the heck is it we in court? So I figured I'd walk you through how we look at cases. And just to give you a little context of how we operate, let's see, I would like to show you kind of my claim to fame here in Virginia. I like to say a case that was pretty important to me. I represented, and this was back in 2018. I went to undergrad at the University of Virginia in Charlottesville. If you recall, in 2018, there was this horrific Unite the Right rally, and an individual was charged with assaulting the guy that essentially created or organized Unite the Right. And so I represented somebody who was alleged to have assaulted that organizer the day after this young lady was tragically killed when she was ran over by a vehicle when they were protesting or counter-protesting these Unite the Right rally goers. And so my client was charged with assaulting this guy, Jason Kessler, when he then following day after this tragic death tried to put on essentially a little rally of himself, a little press conference. And so people jumped him. My guy was alleged to have assaulted him essentially with a single hit or a single punch. And we ended up having a full day jury trial. And there was no injuries claimed. The whole thing was caught on video, and we ended up putting it up in front of a jury. And we had this interesting article. First time I ever thought I'd make the Rolling Stone, or any cases I hadn't make the Rolling Stone, but they essentially titled it "Fines a Man $1 for punching a white nationalist." And so, and the case was important because the jury there had every reason to acquit, because this guy was just an asshole. I'm just going to put it straight up. He was an asshole, but there was an alleged assault that happened on video, and it was kind of hard for a jury to get past that. And they ended up convicting him, but fining him $1. It made the news circuit and all that kind of thing. So, but that being said, it's just a good example that you can have a nominal touching there. There was no alleged serious assault. There was no alleged stabbing or anything like that. It was just essentially an alleged swing and not even a connected punch, more of kind of a graze, I would say. And there was still a conviction. So you still have to take these things very seriously. And I totally understand that. And to help to walk through this discussion, what I'm going to do is share a little PowerPoint presentation that I created that'll help us walk through. So give me just a moment. And so I created a little PowerPoint to help us walk through this. And really, as you can see here, it's pretty straightforward, nothing fancy. But essentially, how do we evaluate assault cases in Virginia? And just to be clear, this case, I think this discussion is adequate for both domestic assault charges, assault and battery charges, as well as simple assault and battery charges. So if you're charged with either count, I think this video should be useful for you. The difference between domestic assault and battery and simple assault and battery is really the relationship between the alleged assaulter, the defendant, and the complaining witness, the alleged victim. When it comes to domestic assault and battery, as you might have surmised, the alleged assault and battery is between family members. When it's a simple assault and battery, it's between non-family members. So, let's say you're alleged to have assaulted somebody at a bar that you got in a fight with, that kind of thing. I did want to just put here a caveat. Every case, particularly assault and battery is unique. It has a unique set of facts, context, all those kinds of things. So this video is not to be, taken as legal advice or used as argument in court, that kind of thing. It's really to give you a sense of our general view of how we evaluate cases. But with every case that I get, I'll dig into the details of exactly what happened, all the evidence, before I can really give specific advice on any given case. So if you have an assault charge, or you have an assault and battery, or family members have an assault and battery charge, we practice primarily in Northern Virginia, Fairfax, Alexandria, Arlington. I used to be a public defender out in Loudoun, so we go there very often. For more impactful cases like the Charlottesville case, I'll go further. And so if you've got something that you think warrants that, then we can talk. But primarily we're practicing in Northern Virginia. So with that being said, let's now focus on what we're talking about here. So first of all, I do think that it's important to define what assault and battery is in Virginia. And here I've employed the model jury instructions. In Virginia, what we do when we're arguing in front of juries, we've created, or not we've created, but there's a committee that's created essentially statements of the law pertaining to Virginia model jury instructions. And essentially the jury instructions, if you go in front of a jury, before the case is argued in closing to a jury, the judge actually reads these definitions to a jury about how to define an assault and how to define a battery. So that's actually instructing the jury of the law. If you have a bench trial, let's say you're in the juvenile and domestic relations court or the general district court, I will read these to the judges, but they're more apt on what the law is because they're judges. And to be a judge here in the general district court or the juvenile and domestic relations court, you have to have been an attorney. Hopefully you've tried some of these cases so you understand that. So for the most part, they're well read on the law. That being said, I don't just assume that. I always try to, when I'm giving a closing statement in front of either a judge or a jury, I want to be very 1,000-foot view, very basic, very plain spoken. So I will overview the law with them. So just to quickly here, what is an assault? That's an overt act intended to do bodily harm to another together with the present ability to cause such harm, or an overt act intended to place the person in fear of apprehension or bodily harm that creates him or her a reasonable apprehension of fear. So what that means is if you're charged with just an assault, you don't even have to have touched somebody. You just have to have done something, either tugging a swing at them or bucked at them. That could technically be an assault and not even have physical contact, so long as either you did it to put them in a place of fear, a reasonable place of fear, and you had the present ability to do that. So you want to make sure you understand that. A battery is the willful touching of another without legal excuse or justification done in an angry, rude, insulting, vengeful manner. And again, that really means you have to have had the intention to do so. So you can have a lot of charges will be at both assault and battery. And when you have the assault and battery, the definitions are subsumed into each other. And so a battery can be enough or an assault can be enough. If you're charged with just one or the other, then you're going to be looking at, how the facts are to that. So, and every case is a little bit different how they charge it. So that is the overall definition. Now, with that being said, when I'm looking at a potential assault case, the first question I'm always going to have in my mind is whether an assault and battery actually occurred. So how do I find that out? I'm asking my potential client, tell me exactly what happened. Tell me the actual touching that happened. If you're saying that there was actual contact, what was the context of that touching and all that? So I want to know those exact facts. I also want to know what other evidence it will be used to establish by law enforcement whether or not a touching occurred or whether or not assault occurred. So talking about independent witnesses, if this, let's say they happen in a public place, or let's say it's between family members, there's a domestic assault, or witnesses at home, maybe kids involved, where they would be able to testify as to what happened. Are there photographs that corroborate? Is there video? Sometimes things are caught on video. Like I said, going back to my Charlottesville case, there was literally news agencies there looking at this press conference and literally caught it on video. So I'm looking at both what I think the complaining witness, the alleged assaultee, the person, the alleged victim would say based upon my client's version. What will they say based upon their version, and then what other independent evidence would be there to corroborate the versions of events. Let's assume there is touching, right? Let's assume my client says, yeah, look, I did have physical contact with this person, but it was because they were coming at me and I had to push them away, or they took, my phone and I was just trying to get the phone back. So if there is touching, was the touching justified? So was it self-defense? Were they in a position to essentially fear for their own safety and taken proportional action? Or even if it was justified, did it go beyond that? So it's self-defense, and this isn't meant to get into the weeds of what self-defense is, but like, for instance, I've had cases where there's an alleged push, and then my client then allegedly, hit him with a baseball bat or allegedly stabbed them. You have to use proportional force when you're using touching as defense or self-defense. So what is the context there? The other important thing to know is whether or not my client actually made statements to law enforcement. And so I always prefer, and this is the reason I'm always telling people, when in doubt, assert the Fifth Amendment, meaning you're not admitting or denying, you're asserting your Fifth Amendment right to remain silent. They can't use that silence against you. So I would prefer in every case my client to have said nothing to law enforcement. But if they did have statements, did they actually admit to an assault and battery? And I just realized I misspelled battery. I did this PowerPoint pretty quickly, so there's probably misspellings, that kind of thing. Did my client admit to an assault and battery? Or did they make statements that would give context to self-defense or other explanation as to why it was not an assault? Just to be clear, if my client confessed, so they essentially admitted to all elements of the assault and battery, it's pretty hard to get around that if you go to trial. All the prosecutor needs is what we call slight corroborating evidence. So let's say my client admitting to my wife client admitting to smacking the husband, and then he has a small scratch on his cheek, and just because she did it because she was mad at him, for instance. That is confessing to assault and battery. You're admitting you did it in a rude, vengeful manner, that you had physical contact and you didn't have any legal justification. It's not like she was defending herself in this hypothetical. And then there's slight corroborating evidence that shows a scratch. In those instances where there's a confession and slight corroborating evidence, even if the complaining witness doesn't want to testify, the court can still find enough facts of guilt under the law. So there can be situations where the complainant refuses to testify, and then the court can still prove the case based upon statements of my client. So that's something I'm always sensitive to. The other thing is you may have made statements that are innocuous or outright denying, but then law enforcement's trying to twist that version of what you said. So fortunately in Virginia, at least in the Northern Virginia jurisdictions, we've become very used to having body cam footage given over by the prosecutors. And essentially what that means is when you're being interviewed by law enforcement, they've usually got a running video feed that is recording everything that's stated. So it's no longer I have to rely on what the officer's interpretation of what you said was. I actually get video, and then we can actually see word for word what was tested, what was stated. And many times this is beneficial to my client. So I'm a big fan of body cam footage. I think there are some lawyers that don't like this because maybe it shows that their client's guilty. Sure, that can happen, but in my experience, oftentimes this body cam video is useful, if nothing else, to provide us a defense and context. But also sometimes you need to be aware. Like sometimes my clients need to be aware that, look, the evidence is bad and it's on video too. So I think at the end of the day, the net gain of having body cam video is both for the prosecution but also for the defense. So I'm glad it's there. Were there injuries documented? Now, to be clear, an assault and battery, an assault does not require injuries. Again, going back to my Charlottesville case, there wasn't any alleged injuries there except maybe some ego injury. But there doesn't need to be bruising, no scratches, things like that. A push, a slap can be enough. Let's say you throw a glass of wine on somebody. There's no injury there except maybe to the clothes, but there doesn't need to be injury in order to be guilty of this. So, but that being said, if there were documented injuries, that's just another a piece of evidence that I'm considering, and can the government makes its case. The other thing is what the context is around the alleged assault. Is there motive that would prove that my client's guilty? So, for instance, did my client confront the complaining witness over something that they were suspicious about? Hey, were you cheating on me? And so, to make them angry and more likely to have committed an assault in a judge's eye. Or was this what I kind of call bullshit cases, like where it's obvious? I've had a lot of cases where, and this is tragically between domestic assault cases, where it's clear that one spouse is trying to gain up leverage on the other spouse in the context of a divorce case. So, they'll entice the other person to essentially have what I call a nominal assault, where they'll run them into the ground, insult them, say these terrible words, get the camera up in their face and videotape in their face, and then when the person says "get away from me" or something like that, or gets mad and slaps them on the wrist, they'll then go get a warrant for an assault, and there's no alleged insults or injuries, and it truly is technically, arguably, an assault, but in my view, it's kind of bullshit. And even if you're technically guilty of an assault, this is context that when I'm considering evaluating a case, and also when I'm talking to a case with a prosecutor about what I think is the appropriate outcome, the context matters. And oftentimes I've had cases where it's clear that somebody has filed for divorce and they're trying to either get up one on the property settlement agreement or custody, and they're truly misusing the criminal justice system. And I will tell the prosecutor, look, I think this is ridiculous that we're here. And sometimes that can be useful, sometimes not. And sometimes prosecutors aren't swayed. They're by the book and they say, look, an assault happened. It is what it is. But whether it's in front of a prosecutor and trying to negotiate a case, or in front of a jury, I want to give context. That can oftentimes be useful, even if you're technically going to lose. And again, going back to that Charlottesville case, the context there was essentially a white nationalist was holding a rally and then essentially trying to, in my view, profit from that by holding this rally the next day or the press conference the next day. And while I think there are reasons that I think we could have easily gotten an acquittal had the judge made different decisions, the context was certainly relevant, particularly in sentencing when they gave a $1 fine. And I think that kind of speaks for itself. So now, the other thing is, what's the relationship between my client and complainant? Obviously, that goes to whether it's a domestic assault or simple assault and battery. But also, again, kind of going to the context is, for instance, I've represented a lot of wives that have been in just horrible relationships, and the complaining witness is a husband that's essentially been abusing them either verbally or physically for years, and then this moment happens where then they're trying to take advantage of the system, and then getting the abusee, the person that's been abused, charged with a crime. And I think it's absolutely relevant and important context in that relationship. Were any children present? That's a big one when it comes to domestic assault charges. I think that judges are going to be concerned if there's an alleged assault and children are present, because it just kind of goes to the context of what's happening. Regardless of what's going on between parents, judges want to protect children, and to see to have a 13-year-old testify that they witnessed, dad or mom abused mom or dad, or assault. That's never something that that's always a bad fact in a case if I'm having somebody charged, but it's also something that you need to be aware is definitely relevant in a case, and going to be relevant for a judge or jury's consideration, whether it's to guilt or innocence or the actual sentencing. And then again, are there claims serious injuries? I will tell you, the vast majority of the assault cases that I handled, domestic assault cases, there are no claims serious injuries. It's, again, a push or a shove, that kind of thing. And so it matters for purposes of guilt or innocence, but also sentencing is a big deal. If there's an alleged serious injury, That can be a big deal about whether or not a judge is actually convict. It can also be a big deal whether they're going to grant a deferred finding, and we'll talk about that in a little bit, or is my client likely to get actual jail time. So that's obviously part of the context. And actually, as I'm thinking about it now, the background, another thing that I should add is what is the history of my client? Do they have any criminal record? Is this a first offense or multiple offenses? Whether it's between this alleged victim or not, whether it's between other individuals or not. Do they have other concerning records, prior convictions of assault, prior convictions for felonies, things like that? That's going to matter. So that's also context. And long story short, as I said, usually my clients, for a vast majority of my cases, they're professionals that just happen to have caught themselves in a bad situation, no criminal records, no prior alleged assaults, things like that. And it's always useful. And it's always, it's not necessarily always outcome determinative, but it's very useful in knowing as far as our concerns case are. Now, the next part is what are the risks at trial, right? And that's kind of weaving into what we just talked about. Is a judge really going to give jail time? In cases where it's a nominal assault, a push or a shove, no criminal record, a judge usually is not going to give jail time in an alleged assault case. In a domestic assault, which I've always found odd versus a simple assault, domestic assault, they actually have a deferred finding. Essentially what it is a first offender program. So I've always found this odd, but you get essentially one simple assault of your significant other and you can get deferred finding, whereas that doesn't exist in the simple assault world. I just found that odd. I would think it would be the reverse, that if you're going to do first offenders, it would be between, an assault for somebody you don't know or don't have a real relationship with, or at least a blood relationship with, but that is what it is. But in many cases, particularly in deferred findings, in nominal cases where there's no criminal record, you can go to trial and the judge still has the discretion to give a first offender program, where essentially there's a finding of a guilt, but they'll dismiss it after a year or two, depending on compliance with certain conditions. So I oftentimes will recommend the clients say, look, they're asking for you to take a deferred finding. I think we have at least some chance of winning at trials, and I don't think a judge is going to do worse than a deferred finding. So I may recommend jail, even if the facts are stacked against us. So just something to think about, and if you're having an attorney, something to talk with them about. Also, what does the evidence look like at trial? Is my client a good witness? Now, this is part of my experience with the criminal justice system and the unfairness when it comes to certain aspects of it. I think in Northern Virginia, we're one of the more fair systems, but we're still a human system. Is there unfairness when it comes to the wealth of my client? Absolutely. Is there unfairness, I think, when it comes to the race of my client? Again, I like to think in Northern Virginia, we're above the fray there, but it exists. In other jurisdictions, I'm more concerned about that. But the other thing that is kind of overlooked is my client able to tell a good story? Are they articulate? Are they persuasive? Are they likable? Are they able to communicate well? This bodes well for them if they're able to do all those kinds of things, which from a fairness perspective is weird, right? You would think that being able to tell a good story would not and should not have any impact on whether or not you're going to be guilty or innocent in any given trial. But unfortunately, that is the system that we have, and people that can tell their stories well get a leg up. People that can relate to a judge or a jury get a leg up. And look, at the end of the day, my job as an advocate for my client is to put them in the best position to win the trial. So some clients are naturally gifted at communication, and it's not a whole lot of work that needs to be done. Obviously, we're going to prep a trial, and as I'm envisioning what's going to happen at trial, I'm thinking about how they would testify. Others we're going to need to do more work with. That doesn't mean that they're going to be a bad witness, but they're going to need more work. And look, the reality is some people are just going to be bad witnesses, and I have to consider that when I'm evaluating my case and when I'm advising my client. Look, I'm not going to keep it a secret. If I think my client's not going to be credible, I'm going to tell them that. Now, ultimately, it's going to be their decision, and ultimately, what I think is not ultimately the end-all, be-all. But I think if you're hiring me, you want that context. So that's something to think about. But it's not just how my client's going to testify. It's, are there other witnesses, or is there video? Is there text communications after the fact where, you've texted, if you're charged with a crime, you've texted them, sorry, I assaulted you, or, I shouldn't have hit you, or things like that. That's other evidence that needs to be considered in whether or not we're going to win the trial, but also, is a judge going to give jail time, that kind of thing. And so it just needs to be considered. So next, are there other special circumstances to my client's case? I do represent a lot of professionals, doctors, nurses, teachers that have licensures, lawyers, things like that, where they cannot have an assault on their record, because an assault is going to look like a violent crime, that they may have to take more risk. Whereas, someone that their record doesn't matter as much to their profession, maybe they're not willing to take as much risk. Maybe they'll be offered deferred finding, so they're more likely or less sensitive to that. I represent a lot of people with immigration status. So, here on a education visa, or here on a work visa, here on a temporary protected status visa, where we have to be aware of special circumstances, how an assault, how a conviction, how a deferred finding can affect their immigration status. And I actually require for non-citizens to consult with an immigration attorney to give me an immigration opinion as to what the outcome will be, because that will then allow me to then advise them on what risk we should be taking. Now, caveat with the immigration stuff is this is May 28th of 2025. Context is we've got a Trump administration that's essentially saying we want to deport everybody, and politics are what they are. But I oftentimes find that means minority clients, Hispanic clients, and so there's going to be some sense of uncertainty there always when it comes to this administration. Should just be aware, but it's definitely something that we want to talk about, especially if you're not an immigrant and not a U.S. citizen. The other thing is this an actual innocence case? And what do I mean by actual innocence case? I have a fair amount of people that call me up and say, James, I'm just not guilty. This is not right that I was charged. I didn't admit to it. I'm going to testify I didn't do it, and I don't care. I don't care what the consequences are. I need to have a judge acquit me, or if we have to appeal it to a jury, I want to tell my story. And if I have a client that's saying to me, James, I'm willing to take this to trial, I am not guilty. At the end of the day, I want to be clear. It is ultimately your decision about whether or not to plead guilty to any given trial. My job as an attorney is to advise you, to help you make legal decisions, to help try your case. But whether or not you want to go to trial or accept a plea agreement, ultimately is going to be your decision, the client's decision. No attorney can take that decision away from you. No attorney can make that decision for you. So oftentimes clients will tell me that they're actually innocent, and let's go for it. Let's go. And so that's going to be something that ultimately the client's going to need to decide. But as in my counsel, when I'm giving advice, I want to know, are you actually innocent? It puts more pressure on me, because seeing an innocent person convicted, those are the worst set of facts that you can have as a criminal defense attorney. But that being said, if we're not willing to fight the fight, then leave the job. And so I want to know if you're actually innocent, and if you want to fight it to the end, that's going to be ultimately your decision, and we're going to go to the mat. So this is not the end-all be-all analysis. This is kind of the 1,000-foot view, a general framework that we use here, that I've used in my practice. I've been practicing about 16 years. Tried a lot of assault cases. Out of the numbers of cases that I've tried, assault cases is it. I do personal injury, medical malpractice. I do a lot of criminal defense as well. I've had a lot of trials over my years, but if we're talking about bare numbers, how many cases have you tried the most? Assault cases are it. So I have a lot of experience here, and every case is different. You think that you've not seen something, but every case is unique. You get different judges, you get different juries, you get different set of facts, you get different relationships, you get different prosecutors, you get different clients. So every case needs its own evaluation. If you're charged with an assault here, or have a family member charged here in Virginia, check out our assault page, our practice page. Make sure, we've shot a few videos on this now. Make sure to like and subscribe to this video channel, this YouTube channel. We try to provide a lot of useful information about Virginia criminal defense, personal injury, medical malpractice law, some more broader videos on policy and law, and kind of more, there's current events that happen that I think I touch on Virginia law in these areas. So hopefully this is useful. Wish you guys the best, but feel free to reach out and